Hi, everyone. I'm Kieran O'Dwyer, Vice President of Corporate Communications at Mutual of America Financial Group. Thank you for joining our webinar today, Secure 2.0, What's Coming in 2025. Just a quick housekeeping note, you can download the slides at any time by clicking or scanning the QR code on your screen. During the webinar, please use the Ask Question box to submit any questions. And if your question isn't covered in the webinar or in our FAQ session afterward, we'll be sure to have one of our colleagues reach out to you. With that, I'm pleased to introduce our speakers today, Earl Jones, Vice President of National Accounts, and Nick Caraba, Senior Vice President and Associate General Counsel. Thanks for joining us, gentlemen.
Hey, Kieran, thanks for having us.
Yeah, Kieran, it's great to be here again. I'm glad to be back with my good colleagues talking about Secure Act 2.0.
Terrific. Well, as we've done in the past, we have a lot of ground to cover again today. We're going to focus on several provisions of the Secure 2.0 Act that plan sponsors should know about in 2025. We're also going to take a look at some of the provisions that are already in effect, along with updated guidance to better understand how these will or may impact employers as they run their plans now and in the future. And we're going to let you know how Mutual America can help you and what you can expect from us, including monitoring for regulatory guidance, plan amendments, and additional communications to help you navigate Secure 2.0 in the year ahead. As you may know, the Secure 2.0 Act was signed into law in December of 2022 and follows up on the Secure Act of 2019, continuing the objective of broadening the appeal of workplace retirement plans. The Act provides employers with opportunities to expand plan coverage and simplify plan rules and administration. And for employees, the Act offers opportunities to save more for retirement and achieve financial success for their own future. Nick, I know there's some themes that we're going to run throughout this conversation today and that folks should be aware of.
Yeah, that's right, Kieran. I think if the folks who are joining us today remember last year's presentation on Secure 2.0, you may remember me saying often that many of these provisions that were enacted by Congress, we're going to have to wait on some governmental guidance and regulatory guidance from both the IRS and the Department of Labor. And so before we jump ahead and talk about the provisions that became effective in 2025, I wanted to just take a brief moment to talk about some of those pieces of guidance that have come out in 2024, because the IRS and DOL certainly both have been very busy over the last several months providing all sorts of guidance on several different issues. They actually began late in 2023, in December 2023, what has come to be known as the grab bag guidance, and provided some informal and initial guidance on many different provisions in Secure 2.0. And I don't want to get into all of them now, but just to mention some of them, there was guidance on the mandatory automatic enrollment provision that we're going to talk about in a few moments. They also gave some guidance, the IRS gave guidance on the so-called de minimis incentive provision, optional treatment of employer contributions as Roth, and some other miscellaneous guidance regarding cash balance and defined benefit plans. But the big key, I think, for everyone in that grab bag guidance was the plan amendment deadline. Under the original Secure 2.0, plans would have had to adopt amendments to come into compliance with the mandatory provisions of the legislation by the end of 2024, which was already a fairly generous remedial amendment period. The IRS pushed that out even further, so that for most plans, with the exception of governmental plans and plans that are subject to collective bargaining agreements, the majority of plans will have until the end of 2026 to adopt required amendments, which gives us plenty of time which gives the government even more time to issue guidance, and plan sponsors and the plan administrator community to come up with the record-keeping infrastructure to comply with these rules. In addition to that one, I listed a bunch here. We'll talk about some of them in the slides to come, but just to mention one in particular, it's the pension-linked emergency savings accounts. There's actually joint guidance from both the Department of Labor and the IRS. And as some of you may know, this what's come to be known as a PLESA. A PLESA account is an optional provision that was adopted under Secure 2.0. It provides the opportunity for plans to allow a separate account to be set up for non-highly compensated employees, for them to contribute up to $2,500 maximum into that account on a Roth basis, so an after-tax basis. And individuals who choose to do that can take out a distribution at any time for any reason to handle any sort of personal emergency. There's no requirements that they meet any safe harbor type of hardship categories, as some of you may be familiar with in a hardship distribution. They're for any personal need at all. There were many questions about this provision, and the IRS answered some of them, focused mostly on anti-abuse protections. One of the questions that came up with this account is, if individuals were to contribute to it and the plan offered an employer match on contributions, individuals could potentially put money into that account, take it out, put money into that account, get a match on it, take that money out for an emergency, and then reinvest into the plan and get another match on top of that. And so this sort of match churning, as it was called, was somewhat of a concern, and the IRS helpfully provided guidance on how plans could adopt anti-abuse provisions. The DOL, for its part, talked in their guidance mostly about contributions and investments, how these monies should be invested. On the contribution side, they suggested that plans can either include or exclude earnings on that amount, so that when individuals contribute to the account, the maximum under the statute is $2,500. But the DOL said, well, it could be $2,500 plus any earnings that get lopped up on top of that. So it could be in addition to $2,500. Or the DOL said you could just limit it to that straight dollar figure. Any amounts contributed after that would have to be returned to the participant. And on the investment side, what the Department of Labor said is that under the statute, these monies that are put into this PLESA account have to be in a stable account that is not subject to market fluctuation. And so they gave some examples of how that money can be invested and protected and not subject to loss in the market. Again, listed here of other provisions, some of which we'll dive into in a little bit more detail as we go on throughout the presentation. But I wanted everyone to know that particularly the IRS, but the DOL too, is actively at work in pushing out guidance on many of these provisions.
Thanks, Nick. Earl, that's a tough act to follow, but figured I'd throw you to the wolves and see if there was anything else there that you wanted to add before we move on to the next slide.
Definitely a tough act to follow, but I'll try. With respect to one of the acts that has gotten particular attention is the qualified student loan payment provision. Basically, due to the inordinate amount of I guess, issues with respect to savings, a lot of individuals are inundated with paying back their student loan debts. The Act provides for employers, plan sponsors in particular, to treat those student loan payments as matching contributions. And so this is for 401k, 403b, governmental 457 plans, and simple IRAs. And so guidance came out in August of this year in about 4 key areas. One, eligibility, to make sure that there's uniformity with respect to who's eligible for the plan. Also certification, that it would have to be an annual certification, and then how plan sponsors would verify that. There are some options with respect to that in terms of how you verify that the loan payments are qualified as it relates to the requirements. And then they gave plan sponsors some leeway as it relates to the reasonableness of how this is implemented, as it relates to deadlines and things of that nature, of the timeliness of when those matching contributions will be disseminated. So it gives some leeway and some room from plan sponsors to be able to administer this. And then some relief as it relates to the non-discrimination testing with respect to how that would be done in 401ks. And so again, this is ultimately in alignment with their goal of enhancing and expanding plan coverage for those who are, inundated with paying back their loans and have been unable to make those contributions to prepare for their retirement, or not doing at the level that they hope to. Gives them some incentive to offer those benefits. And then the first iteration back in 2020 of the Secure Act eliminated the stretch inherited IRA. Previous to that, when someone passes away and a non-spousal beneficiary inherited those assets, they would go into an inherited IRA and then would be required to withdraw, but they could use their lifetime, their life expectancy to kind of stretch and prevent them from kind of depleting those assets. But now with the iteration of the Secure Act, it eliminated that stretch provision, and now all assets would have to be eliminated within 10 years. Nick is going to cover a little bit more about the RMD regulations that impact this particular IRA and then others. But again, in a nutshell, that is just kind of what it is and how it has been implemented.
Great. Thanks again, Earl and Nick, for those insights to help kick off this conversation. As we've seen in the past year, there are many provisions that plan sponsors and participants are focused on, from student loan repayments, as you talked about, Earl, to long-term part-time workers, emergency savings options, and mandatory cash outs. None of these are new provisions per se, but I did want to just maybe take a moment, Earl, to focus on the mandatory cash out provision. It has attracted a lot of attention. Would you revisit the provision, especially highlighting some of the benefits around it, both to employers as they administer their plan and individuals as they look to build savings for their retirement?
Thanks, Karen. And I think, to your point, this is nothing new. This is something that has been ongoing with respect to an option that plan sponsors can implement for their benefit. And so in effect, this is an optional provision that plan sponsors can scrub their roles in terms of their participants within their accounts and transition them to a default IRA. The Secure 2.0 Act increases the limit from $5,000 to $7,000 with the effect of this particular provision. And so again, from $1,000 to $7,000, these plan sponsors can transition these terminated vested participants into a default IRA. Here's the benefit. A lot of organizations that are hovering around that 100 employee mark are subject to a ERISA audit, and that comes with significant costs. So to mitigate costs, the benefit of these mandatory cash outs can actually help them get under that threshold. And then also with various service providers, in terms of their fee disclosure, there may be per participant charge. And so when you're able to do these cash outs, it enables the plan sponsor to kind of control costs. But then also when this happens, a lot of times employees, it's almost like a set it and forget it. There's notices that go out, people are made aware that this is happening. And so now they have an opportunity to still be engaged with their retirement plan and make a decision that's in their best interest. So from the plan sponsor perspective, it actually helps them from a cost perspective, but then for the participant with the notices, it gives them some skin in the game to really make some changes that will work for them. And then also, we didn't talk about this, but there are also account portability services that some service providers, retirement plan providers can implement for these default IRAs, so that when an employee changes jobs, it can automatically be transitioned to their new employer. And so that's a good thing, because one, it eliminates from these participants from just cashing out their plans and not continuing their savings. We don't want that. And then also it allows them to keep track and then consolidate their savings and just continue on. And so a lot of times they have in anyone's career, they may have multiple plans. This kind of simplifies things for the employee, and I think it could really be a benefit.
Terrific. Thanks for the update on that, Earl. Nick, another provision that we keep coming back to relates to required minimum distributions. You touched on some guidance earlier around RMDs, but would you briefly take a step back to walk through the core elements of RMDs and then the new rules for 2025?
Yeah, sure, you bet. Thanks, Karen. Everyone knows that what RMDs do is to eventually require folks to pay taxes. That's what the IRS does. That's what they're set up to do, is to collect taxes. And to the extent that retirement savings are in a tax-deferred basis, the IRS says, well, you can hold on to that tax deferral for only so long, and then you have to eventually pay the piper. For a long time, that time when you had to pay that piper was age 70 and a half. You may remember back in 2019 with the first Secure Act, the Congress raised that age to 72. And then just a couple years later decided that wasn't quite old enough, and so they pushed it up to 73 with an additional increased age 75 that's going to kick in about 10 years in 2032. Right now, as it stands, the required beginning date, which is that's the age at which most individuals need to start taking a distribution either from an IRA or from a plan account if they've retired and they still have money left over in their employer plan. In addition to the age changes, as Earl talked about, the elimination of the stretch IRA, that's also a required minimum distribution provision, and that's going to require any non-spouse beneficiary of a retirement account or IRA to take a full distribution within 10 years of the date of death of the participant or the IRA owner. And so there was some confusion and some questions in the interim between the enactment of Secure 2.0 and this new guidance that was issued by the IRS just this year about whether or not the individuals who had begun taking as a beneficiary annual payments, if they were subject to that new 10-year rule, or they could just continue to take annual benefits as they had already scheduled. And so the IRS came out with guidance saying that no, that the non-spouse beneficiaries, if they've begun taking annual payments, they have to continue to do so until the account has been exhausted. And if they haven't yet, they need to start by 1/1/25 to avoid an additional penalty. But because there was some uncertainty, the IRS did provide a waiver for any penalties of missed RMDs in the interim up until the end of 2024. And then the additional piece that was enacted under Secure 2.0, a little bit separate but related, is the treatment of a designated Roth account within a defined contribution plan, whether that's a 401k or a 403b plan. To take a step back, we know that the RMD rules apply to a traditional IRA, but to a Roth IRA, the RMD rules do not apply. So individuals could be 73, 74, 80 years old and not have to take any required minimum distributions from a Roth IRA. That had not been the case for a designated Roth account inside a 401k or 403b plan. For whatever reason, when Congress set the Roth bucket up inside a defined contribution plan, they kept the application of the RMD rules in place, so that individuals who retired and still had money left over in their 401k plan at work, they were required to take distributions from both their traditional bucket and, if they had money in a Roth bucket, from there as well. What Secure 2.0 did was to say that that money inside the Roth bucket in a 401k plan or 403b plan is not any longer subject to the required minimum distribution rules. And that change is effective 1/1/25.
Great, thanks, Nick. Ever changing on the RMD front for sure. I'd like to move on to a couple of mandatory provisions that we haven't talked about. Earl, automatic enrollment, for one, is increasingly gaining traction in retirement plans as we continue to see a retirement savings crisis in the United States continuing. Now, new minimum contribution percentages and ranges may help. What are some of the key areas of automatic enrollment for 2025, including its benefits, both from an individual and plan sponsor perspective?
So thanks, Karen. This is a mandatory provision that's effective in this particular act. However, it's nothing new. Automatic enrollment has been around for a while. However, the legislators are targeting new plans. And so with this particular act, plan sponsors can automatically enroll individuals with a minimum of 3% contribution rate. They have to select it between 3% and 10%. And they can put also a automatic escalation. In other words, you can start off with a 3% contribution rate, and then each year you can go up by 1%. Ultimately, the plan sponsor would need to predetermine what the minimums as well as the maximums are at the outset. But overall, full disclosure would have to be made to the plan participant so that it would give them all of the relevant details, contribution rates, the opt-out instructions, which is critically important, as well as the investment options, particularly the safe harbor QDIA, which is the qualified default investment alternative. And so overall, this gets at the heart of the act in terms of expanding plan coverage. They didn't go all the way in terms of forcing all plans to have automatic enrollment, just new plans. And so again, this targets those new plans to put this in place for their employees. However, there's some benefits to this. For startup plans, there are tax credits that will mitigate against the administrative costs for the implementation of the retirement plan. 100% of the startup costs up to $5,000 is the credit. And then also there are some exceptions to this particular provision. Businesses with fewer than 10 employees, plans already in place prior to December 29th, 2022, businesses in operation less than 3 years, simple 401k plans, governmental plans, and church plans are all exempt from this particular provision. In essence, this is, a major, in my opinion, major benefit in terms of creating awareness, not only for the retirement plan for these participants, but keeping them and making sure that they are engaged in their retirement plan savings. At the very least, they would have to engage to either opt out or to see, what it is that they're plan sponsor, the employer, is doing on their behalf. And so, again, this is the provision that's in place, but it's nothing new.
Earl, that's great. I would just add on to that the IRS did issue some guidance on this, as I think I mentioned at the top, in that grab bag guidance back in the end of 2023, and sort of addressed this question that you were getting at too about what exactly is a new plan, and in particular in the context of plans joining together in a multiple employer plan. There was some questions about whether if two pre-existing plans joined together into a new MEP, whether or not that would be considered a quote-unquote new plan for these purposes. And the IRS, for that specific question, basically said, no, if you're two existing plans already and you join into a new MEP, you wouldn't be considered a new plan. And ran down several other scenarios in that guidance too, to be to let folks know when these new rules would be triggered. And just to put a nuance on that, this is a sort of a strange provision in that it's both retroactive and prospective at the same time. The new automatic enrollment is already effective, but it didn't have to be implemented, or doesn't have to be implemented until 1/1/25. So the first automatic contributions taken out of people's paychecks and put into a plan will begin with that first payroll in 1/1/25 for plans that were quote unquote new beginning back in 2023.
Thanks, Nick, and thanks, Earl, on this discussing this topic. I know we're going to be hearing a lot more about automatic enrollment as we go through 2025. Another mandatory provision, not new, but with important update kicking in during 2025, relates to long-term part-time workers. Nick, we talked about this segment of the labor force in past webinars, and you touched on them earlier. Still, would you give a broad overview of the provision and then shed light on what's coming in 2025?
Sure, you bet. So back in 2019, under the first Secure Act, Congress enacted a provision that required 401k plans only to include in enrollment employees who worked at least 500 hours for 3 consecutive years. And that provision was not yet even in effect before Congress enacted Secure 2.0. And in that bill, there was a provision to expand the application of this long-term part-time worker provision to 403B plans, and also reduce that threshold from 3 consecutive years of working at least 500 hours to 2 consecutive years of working at least 500 hours. That new rule, the 2-year rule, and the expansion to 403B plans is going to become effective for the first time in January 1, 2025. Again, sort of like the automatic enrollment provision we just talked about, 1/1/25 for 403B plans is the first year that those individuals need to be offered an opportunity to enroll. But there is a look back period to determine that 2-year period. So plans will have to have looked back to 1/1/23 to see if any of their employees had worked at least 500 hours over those 2 previous years, and then they'll be offered enrollment beginning 1/1/25. The IRS did issue some helpful guidance for particularly for the 403B plan community. There were lots of questions, and we talked about it a little bit last year. As 403B plan sponsors listening in will know, there's something called the universal availability requirement for B plans, which basically says what it is, which is all employees need to be offered enrollment in a 403B plan. There are some exceptions, though, and the biggest exception to butt heads with this long-term part-time rule is the exception for individuals who normally work less than 20 hours a week. That is in direct conflict with someone who may work at least 500 hours in a year. And so the question was, which rule is going to prevail in the conflict between those two? In the guidance the IRS issued, they said it's the long-term part-time rule that's going to prevail. So that if you have someone who normally works less than 20 hours a week, but nonetheless work at least 500 hours in two consecutive years, that individual will need to be offered enrollment in the plan. And just to remember and to underscore, being offered the opportunity to enroll in a plan is for elective deferrals only. The plan must allow them to contribute their own money, but does not need to provide any employer match or employer non-elective contributions to those accounts. The other piece of the guidance related specifically to another universal availability exception that is allowed for student workers. And since a lot of public schools and universities offer 403B plans, the student exception is one that many plan sponsors take advantage of. The IRS did clarify that that student exception to the universal availability rule can still exist, and the long-term part-time rule does not apply to students. So that was helpful and a significant win for folks in the 403B plan community that do employ students at a part-time basis and don't want to provide them opportunities to enroll in the plan. It's a really tricky provision, and there are lots of ins and outs. We've been working with our record keeper partners to enhance our record keeping infrastructure to administer for these plans, and I can tell you that lots of work has gone into understanding these rules because they are a bit tricky. If you have any questions about these, I would suggest consult with your Mutual America contact and get you help on the technical aspects of these rules.
So Nick, thank you for that overview. And I think it really is amazing. I think it gets at this particular provision, gets at the spirit of the overall act of enhancing coverage. And for someone who, works with our field offices and works directly with these plan sponsors, this gives us a unique opportunity to work with these individuals that were not being covered. And now they have the ability not only to make their savings, but also to tap into some resources that they may not be able to get elsewhere. And so I think it's a really wonderful opportunity, particularly for providers across the landscape, but also for Mutual of America, to be able to service these individuals that were not included under the law. And so I think it gets at the heart of the entire act and the intention behind the legislators. So it's a really good, and I really want to kind of put a pin right there in terms of its benefit.
Yeah, I agree with that. It's a good insight. It really does get to what Congress was after, expanding coverage.
Yeah, I appreciate the insights from both of you on this front and covering it across all spectrums. And I think the next provision I want to talk about is also going to capture that spirit you're talking about, Earl. Nick, there's been a lot of focus on enhanced catch-up contributions, which is an optional provision. So this creates an additional opportunity for workers who are later in their career, but may not have saved enough for retirement to help boost. This gives them an opportunity to boost their contributions now. So, but with that said, what can you take us through some of the core aspects of this provision that individuals need to know? And what are some of the critical factors for employers to understand as they consider implementing the provision?
Yeah, so this is an interesting provision. This follows up on the catch-up contribution that was enacted long ago as part of ECTRA. And that allowed individuals who reach age 50 in a year to contribute more to their plan. And this will allow people who reach ages 60 through 63, so 61, 62, and 63 in a year to contribute even more. Right now, that's going to be an annual increase based on the cost of living adjustments that the IRS publishes each year. So for 2025, it's going to be $11,250 that individuals ages 60 through 63 will be able to contribute as a catch-up. As you mentioned, it's an optional provision, and so I think a lot of employers are thinking through whether or not they want to offer this, even if they offer just what we'll call now a regular catch-up, the age 50 catch-up. And probably it's going to depend on a number of factors. One will be, frankly, just demographics. Depending on the age profile of your planned population, this provision may or may not make sense. And then also the other consideration is going to be, frankly, one of cost. And if the plan provides for an employer match, though this extra enhanced catch-up will be subject to that match, unless the plan wants to adopt an amendment to exclude these additional amounts from the employer match, which is permissible as well. So lots of different things to think about, but an interesting opportunity for those reaching that magic age of retirement to contribute even more to the plan.
And Nick, listen, what I would add, and I want to thank you for just unpacking this for us. I think this underscores just kind of where we are in the country and people's overall lack of preparedness to retire. And so this particular provision should cause people to take note and to serve as another reminder that they need to put some things in place to prepare for the inevitable. My dad would say it's foolish not to prepare for something that is going to happen. And so this is one of those check marks. This is one of those reminders I think is necessary for all of us to do what's necessary and put us in a better position. So I think this is a great part of the act.
Earl, great wisdom from your dad there. Thank you. Thanks to both of you on that. I do have one more area I want to cover off on, and I'll stick with you, Earl, on this. There are a couple of or a handful of optional provisions focused on distributions, including those related to domestic abuse and federally declared disasters. Could you just run briefly through these, starting with the emergency distributions?
Sure. And so I think there's the elephant in the room for those who are considering to participate in a retirement plan. What if something happens? That calculus sometimes causes people not to want to be involved, because if something happens, where are they drawing those assets for in terms of emergency or situations that may arise? And so anticipating that, this act provides for several circumstances. One, emergency distributions that you can withdraw for any unforeseen personal expense up to $1,000. Also, there's a domestic abuse provision there that you can withdraw the lesser of $10,000 or 50% of your person's vested account balance. And then also you can actually repay that back over 3 years. All of these, not all of them, but these particular ones, you can self-certify and say, hey, this is the issue that I have, and then take the required withdrawal. There's also a provision for terminally ill individuals, and they may make penalty-free withdrawals of any amount, even if they are still able to work. However, the provision states that you must be medically certified in order to affect this particular provision. And then finally, victims of federally declared disasters, you'll also be able to take a withdrawal. Now, it has been reduced from the $100,000 number that was previously affected, but now it's reduced to $22,000. And a person can also spread out the withdrawal income over 3 years. And so overall, this act enables participants to, in the event of some unforeseen circumstance, some challenge that a person is facing, be able to access funds if needed, but also to be able to replenish those assets in a way that continues your growth and your savings toward the future. And so, they're anticipating these issues that in previous years would prohibit people from participating because they're, they want to be able to access something in case things happen. So that's the provision there.
Daryl, I would just add to that, it gets a little bit confusing, at least to me, with all these different types of emergency distribution options. We note that at the outset of our presentation, I talked about PLESAs, which is a completely different provision in this act that allows individuals, at least non-highly compensated individuals, to save in a separate account in their plan up to $2,500 a year to use for any personal expense they need. So that's in addition to these. What these provisions have in common, I think why we grouped them here together, is that they're all exceptions to the 10% penalty tax for early withdrawal. So that under normal circumstances, if you take money out while you're still employed, even for a hardship distribution, for instance, you're going to be charged that 10%, what's called 72T for the provision of the code, excise tax. So these are all exceptions to that as well. And what's interesting about them is that they don't necessarily need to be part of a plan document. In other words, if a person can take a distribution, they're eligible for one, they can do that. And if they would normally have been subject to that 10% penalty tax, for any of these provisions, they will be excused from that tax. And so on their own individual tax return, they can claim an exemption to that penalty tax. And then, Earl, as you mentioned, have the opportunity to repay back to the plan or to an IRA if the plan doesn't permit a repayment of these distributions. So that definitely underscores that theme, which is to encourage people to put money in the plan, knowing that if they have an emergency, they can access that.
Great, thanks, guys. Seems in many ways that the Secure Act is a gift that keeps giving. So, a lot of great insights on this. And before we get into the Q&A, I just thought I'd give a quick look ahead. I'm not going to get into details here because we've covered a lot of ground and still have some discussion to go. But plan sponsors should be aware of provisions in the coming years, such as the Roth catch-up requirement coming in 2026. And notably the Savers Credit in 2027, just to name a couple. You might recall that the IRS delayed the implementation of the Roth catch-up in 2023 until January 1st, 2026. So more to come on that in the year ahead. But for now, in the meantime, just want you to know that Mutual America is here to assist plan sponsors and participants. Nick, you talked about regulatory guidance earlier. What can plan sponsors expect from Mutual America on this front?
So we try to continually communicate with our clients on regulatory updates through various methods, whether that's the plan sponsor news articles that go out or other webinars like this that Earl and I participate in from time to time. And I know all of our account reps are out there talking to their clients and giving them the most updated information that we have. But we are closely monitoring what goes on, and we see what the DOL and the IRS both have on their regulatory agenda for the upcoming year. And know, just to give you a couple of insights as to what we know will be coming, additional regulations on that 72T tax provision I just mentioned on the 10% penalty tax. There'll be new comprehensive regulations coming out in the upcoming year. And on the DOL side, as part of the Secure 2.0, they are required to create a database of missing participants to help find lost participants and link them up with their money. And so that's a new regulatory project that they've undergone and should come out in 2025 as well, among many other things.
And Earl, how about plan amendment related news? What should plan sponsors keep in mind here?
So I think holistically, just in terms of those amendments for the mandatory provision, as well as any optional provisions that you would like to implement, work with your service provider with respect to Mutual of America, work with the regional office, and they'll certainly communicate with you as to the next steps to really fully understand the provision, understand what you like to do, and then go through the process. And so again, our regional office team is available to assist, to help you unpack the provisions themselves, but then also to take the next steps in terms of this implementation.
Great, thanks, Earl. Appreciate that. And just I'll touch on communications. Nick talked a little bit about this already. Throughout the year, Mutual America we're going to post articles on our website, provide news and information in our plan sponsor newsletter, as well as other plan sponsor bulletins. I'm quite sure we'll also have a webinar or two on various topics related to Secure 2.0 in the year ahead. So stay tuned for that. Just before we get close here, I'd like to, we do have time for a few questions. So again, I see use your ask questions box to submit questions. And again, if we aren't able to cover your topics, we'll be sure to have a colleague follow up with you. I have a few here. Just looking at one here, maybe Earl, you can take this for auto enrollment. Just want to confirm that the employee specifically has to elect to opt out of participation.
Yes, that's exactly right. And so there will be notices, annual notices that will inform individuals that auto enrollment is getting ready to take effect, and they have the option to opt out, right? Now, it'll be an annual notice, but also when a new hire comes aboard and they don't enroll in the plan, there would be a time period that goes from that, and then they'll receive those notices, and then if not acted upon, they'll be automatically enrolled. But no one is forced to be in the plan necessarily. If they don't want to, they can opt out. But largely, we don't see much of that. Most people stay in the plan once they're automatically enrolled. And then also, they take a harder look and are more engaged in managing their plan or reaching out to resources to help plan accordingly.
Great. Another one here around the enhanced catch-up contributions. For those 64 and older, does the contribution remain the same as for those ages 50 to 59? Nick, I think you touched on this, but if you want to just clarify that, that'd be great.
Yeah, it's a strange quirk in the provision that they only allowed the enhanced catch-up up to age 63. Once you hit age 64, you revert back to the age 50 catch-up, whatever that will be at that time. So it's a strange little hurdle in the act that plan administrators had to work through the record keeping and payroll systems to account for that, but that's how it works.
Great. And I see another question here on, we have other catch-up contribution questions, but I actually just want to jump to one here in the interest of time. Will employers incur fees to implement the mandatory cash out provision? Earl, I know you talked about that earlier. You want to take that?
So overall, plan sponsors should look at their fee disclosure and work with their retirement plan provider overall to kind of assess their fees. And with respect to cash outs, there's no additional fees from Mutual of America for those services, no. Again, when you look at overall fees, it needs to be reasonable, and certainly you need to assess that. But with respect to this particular act, there's no additional fee for the mandatory cash out from Mutual of America, no. But again, there's different service providers that oversee various retirement plans, and that's a question that should be asked.
Great. And Nick, I think you touched on this one a little bit already, but what will Mutual America do regarding updating plan documents. Will notices be provided?
Yeah, absolutely. We work closely with our partners to make sure plan documents and plan amendments are available in a timely way. And once we get closer to that deadline, all of our plan sponsors will receive notice of upcoming plan amendments and what they need to do. Most of our clients that are on what's called a pre-approved plan document won't have to do anything. Those plan amendments will be the ones that are required will be adopted as part of the pre-approved plan document and provided to you. If there are any discretionary amendments that you want to make as a plan design matter, then those would be individual amendments that you would need to execute, but that's something that we absolutely will be able to help you with.
Earl and Nick, thanks for your great answers to those questions. I'm sure we're going to have a lot more questions that our colleagues can get back to you on. With that, thanks again for sharing your knowledge and insights with us today, guys.
Thank you, Karen. It was a joy to be with you and to talk about the Secure 2.0 Act. Look forward to continued webinars and things that we can get out to the field and to our clients and prospective clients. It's been great. Thank you.
Yeah, I echo that. Thanks again, Kieran, and thanks, Earl, for being on today. It's a rare occasion for ERISA geeks like me to get to talk about these things. So I welcome any opportunity to do so. Thanks again.
Thanks, Nick and Earl. Appreciate all your insights today once again. And that's all the time we have for today's webinar. Thank you all so much for joining. Again, you can download the slides by clicking or scanning the QR code on the screen. And before you leave, please take a couple of minutes to complete our brief survey about the presentation. Finally, please know that you can watch the today's webinar at mutualamerica.com at your convenience. Thanks again, and really do appreciate you taking the time to attend today's webinar. Have a great day.